my first guest is Professor Gillian Triggs, who is the past president of the Australian Human Rights Commission and is currently the Vice-Chancellor's Fellow at the University of Melbourne. Since graduating from the University of Melbourne and gaining a PhD, Professor Triggs has combined an academic career in international commercial legal practice and worked with governments and international organisations advising on including human rights law. She is focused on the implementation in Australian law of the human rights treaties to which Australia is a party to, and on working with nations in the Asia-Pacific region on practical approaches to human rights. It is my very great pleasure to introduce to you all Professor Gillian Triggs.
Well, thank you, Wayne, and thank you, everybody, for this wonderful opportunity to speak to the group of emergency nurses that I've long wanted to be able to speak to and express my own gratitude for the work that you've done. And I'll explain what I mean in a moment or two. Thank you, Uncle Chicka, for your welcome to country. And I, too, acknowledge in this rather marvellous lecture facility the Gadigal people of the Eora Nation and respect their elders, especially if any are here this evening or this afternoon. Well, I was asked to speak about the importance of embedding human rights for patients within emergency practices despite the chaos. Well, it was the despite the chaos that rather put me off, because I assumed that nurses were fully in control and there was no chaos. So that part of the topic I'm going to leave you to deal with, because as a layperson, I never really saw it. But I did want to make a special tribute to the nurses with their empathetic ability to work with wider and more difficult situations. And the one that is most important and has been for me in my role as the former president of the Australian Human Rights Commission, and that has been your support for asylum seekers and refugees, and the very, very troubling question of the indefinite mandated detention of children and their families without charge and without trial. Your support, and I believe it was the nurses who first started to speak up for the Australian Human Rights Commission and for the work that we were doing on children in detention. And I think it's because you really are so much closer to patients, to the real situations, and I was really impressed that you had the courage to speak up professionally and to say how damaged these children are and are going to continue to be as they emerge in our society. It was wonderful the way you stood up for the child in Brisbane who'd been brought from Darwin with the burn injury, refusing. I thought it was rather a wonderful technique. I wouldn't have dared do it myself, but you refused to let the child out of the hospital on the basis that if she was to be returned to Nauru, that would be a failure of your own duties as a medical service supplier. And you simply stood against federal government that was insisting on the return of that child. And there are many, many other examples of the same thing. And so I, on behalf of all my former colleagues at the Human Rights Commission, really do respect what you did for us. I know how extremely difficult it's been. Many of you have been to Manus and Nauru and Christmas Island and into all of the detention centres, and you know what those facilities have been like. But also I've got a personal experience that I've never really had the opportunity to thank nurses for, and I thought maybe this was the time. Many years ago, my daughter was born with a very, very profound disability, and I was told within hours of her birth that she would live a few hours, maybe a few days, but basically we should say our goodbyes and that would be the end of it. Well, over the next 2 or 3 weeks, I was constantly coming into the hospital where Victoria was to be with her, thinking that she didn't have very much time to go. And one day, this wonderful nurse said to me, "Look, Gillian, you keep coming into the hospital and you know, it's taking up a lot of your time, and can I tell you, I don't think this little girl is going to die at all. I think she's got a way to go. Why don't you take her home?" So I went home, got the bassinet and all the equipment for getting her in the car, and we picked her up. And that's the beginning of a 21-year story of an enriched, happy and wonderful life. But I think without that nurse who had the insight to know that there was a strength and a determination to survive, I suspect she would not have done. So I've always been very grateful to that very personal ability of nurses to speak up in the interest of their patients. Well, we are here then today to talk about the responsibility of nurses, among others, obviously, in the medical profession, to ensure that patients have access to the best available nursing care, that it's informed by evidence, ethics, the empathy I've spoken about, and, of course, care. But emergency nurses have very special challenges as they work in different environments, from small rural clinics, international aid agencies, as we've seen from this wonderful video, and large trauma hospitals and community centres. But there are significant challenges. In Australia, nearly 3% increase annually in the number of patients now present for treatment, and have done in these rising numbers as researched over the last 5 years. 7.2 million patients coming into emergency departments in the years 2013 to 14. In a context in which there are diminishing resources and pressures on bed access and a lack of skills. And this is not an area, I'd have to say, that I knew anything really very much about. I'm a member of the public, a lay person. I know something about international law and international human rights law, but I don't really know very much about emergency nursing. But over the last few days, I've been doing a little bit of research, and I found it astonishing what's actually been happening. And you're, I assume, much more aware of this than I am, but I've been very conscious of the particular problem of aged care, that aged care facilities have had a reduction in the skilled nursing employees from 36 to 24% over the last 2 or 3 years. And that has had a curious, unforeseen and unintended consequence, and that is that less well-trained staff are now sending people from aged care facilities to emergency departments, where those nurses are then required to exercise the special skills that they have to decide what happens next. Now, I'm sure that was never the intention, and I've been speaking to this wonderful person from Finland who's going to be speaking to you with much more authority on this than I am, about that this is a problem that she faces in Finland as well. So it's not peculiar to Australia, but it's something we need to be aware of. But it makes it clear that we need specialist training in emergency work, because it is a unique practice dealing with what's been described as unstable, undiagnosed patients, often presenting unexpectedly. Emergency care is provided to all age groups in a variety of settings, including out of hospital and in hospital situations. Emergency nursing covers many areas of care, ranging from minor and major illnesses and injuries, and its uniqueness lies in the diversity of practice, where the emergency nurse specialist is able to apply principles and concepts in differing situations. Now, I won't go through exactly what those very special skills are, but obviously one of the most important, is the ability to make rapid, informed decisions as to how to deal with this dynamic and unpredictable situation, to assess patients in a timely way, so that they can receive the level of treatment that's appropriate to their circumstances. This is especially challenging in the what I'm sure can be a chaotic situations, and even, I suspect, very dangerous environments in emergency departments. Well, where do I come in on this kind of issue? Well, my approach to healthcare generally, and to high-quality emergency nursing in particular, is that the services should be understood through the lens of human rights. These are not services that are provided if it's possible, or if the policy settings are in place, or because a sovereign nation has an obligation to care for its citizens, or even because of the ethics or the right thing to do. The responsibility is based on a legally enforceable right to health care, both as a matter of international human rights law and as applied in an ad hoc fashion, sadly, by our national laws. But there's also a wider dimension to this. Framing health as a legal right is important because it adds to the understanding in the research and literature of the social causes that link health with social justice. They make explicit the link between health and the construction of a functional democracy, a matter of increasing concern to me as a lawyer for a number of reasons that I'll explain in a moment. Health-related resource distributions, the evidence of discrimination and disparities are analysed not only in terms of their impact on health, but also in relation to laws, policies and practices that limit popular participation in decision-making and, in turn, the establishment of a genuinely democratic society. Well, let me just begin the journey to understand what these international legal principles are. And they begin with the World Health Organization. You won't be surprised, in 1946, the World Health Organization found that the right to the enjoyment of the highest attainable standard of physical and mental health is a right that UN specialized agency would enforce. It describes health as a state of complete physical, mental and social well-being, not merely the absence of disease, and says that the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being without distinction of race, religion, political belief, economic or social condition. And that concept of the right to health under international law is found in the 1948 Universal Declaration of Human Rights. And I mention this declaration in particular because that rather marvellous man, Dr. Evatt, whom at least some of you will remember or know in this audience. He was an extraordinary Australian, a Minister for Foreign Affairs, and went across to the United Nations at the request of Eleanor Roosevelt to help draft the Charter of the United Nations itself, but also the Universal Declaration. He was feisty, he was brilliant, he was argumentative, but he got that provision on the right to health in the Universal Declaration, and it's underpinned all of the international law on the right to health ever since. Now, it's been picked up in numerous other treaties, and I won't go through them all, but the International Covenant on Civil and Political Rights, the Convention on Economic, Social and Cultural Rights, the United Nations World Health Organization has now established a special rapporteur on the right of everyone to the highest attainable standard of physical health, a right to a system of health protection with equal opportunities, the right to prevention, treatment and control of diseases, and access to essential medicines. But then there are specific other treaties, the Convention in relation to women, ensuring that special measures be taken in the field of health to eliminate discrimination against women. There's a Convention on the Rights of the Child that requires appropriate measures be taken to diminish infant and child mortality and to ensure that every child receives appropriate medical care. And it's in that context, of course, that the work that I was involved in with the Australian Human Rights Commission on the detention of children in Nauru, Manus, but most particularly Christmas Island. It was so important there that I was able to rely on the credibility of the medical profession and on the doctors and the nurses that came with me. If I said every child on Christmas Island is sick, it would have no credibility at all. But one of your great strengths is that you bring huge levels of credibility, and you gave credibility to the Australian Human Rights Commission and to all of our work. And when one medical doctor and nurse stood up and said, every child on Christmas Island is sick, that is a judgment that had huge credibility and based in evidence. I could not, well, obviously, as a lay person, I could make a judgment that seemed to me every child was sick. I couldn't possibly say that in a way that would have any credibility. So the Convention on the Rights of Child is very important in emphasising the special rights of these children. But there are also, of course, a Convention on the Rights of Persons with Disabilities. And one of the curious and very sad aspects is that it's people with disabilities who most suffer from discrimination and a failure to bring services. So what does all this law amount to? Well, it amounts to some very, very simple principles. You don't need to be a lawyer to go through all of those details. Basically, we come back to a key point of respect for all people, regardless of sexual orientation, their religion, their race, poverty, or disability. Issues like access to medical services, safety, communication, confidentiality, privacy, and an ability to participate, these are all key rights. But when I say these are legal rights, what does this amount to any more than words on a page that lawyers love to talk about? Well, firstly, of course, states are responsible for complying with these conventions. From the very early days of Doc Evatt, Australia has been a major player in developing these international legal standards. Right up until, I think it'd be fair to say, the mid-90s, or perhaps I'd place it from the children overboard misstatement in this age of post-truth in 2001, the Tampa sailing into the Australian waters in Melbourne, and a few weeks later, the terrorist attacks on the Pentagon and the Twin Towers. That was a fundamental year, but up until that time, I think it'd be fair to say Australia was a leader in giving effect to these principles. But there is a very strange phenomenon in Australia with regard to the import of all of those international standards into our domestic law. So if you could hold on to your seats for a moment, I'll explain why. Because Australia has become both exceptional and isolated from these standards. We, believe it or not, are the only country in the world with a democracy that does not have a Bill of Rights. We are the only common law country in the world without a Bill of Rights. We live in a region that does not have a regional convention on human rights. And the treaties that I very briefly mentioned to you have not in the main been implemented in Australian law. It is astonishing that the Convention on the Rights of the Child is not part of Australian law. The International Covenant on Civil and Political Rights that prohibits the arbitrary detention of people without charge of trial is not directly part of Australian law, nor is the Refugees Convention or the Convention on Economic, Social and Cultural Rights. So we have this enormous body of law that I have studied for much of my professional career and had a responsibility for implementing in my role as President of the Human Rights Commission. But if I go to the High Court or if I go to a minister in Canberra and say these are core rights that must be respected with everything we do, I'm told, well, that's very interesting and it may be part of your job, Gillian, but these principles are not part of Australian law. The Australian High Court is not able to implement these principles because if the legislation, the Migration Act in particular and other relevant legislation countermands that or says the opposite, if it's clear, then there's nothing the High Court can do. So these are very significant problems and they're ones that underpin the disconnect that we have in Australia. We do not speak the language of human rights that in Europe, in North America, even our cousins in New Zealand speak with a Human Rights Act. But with that in mind, I was really very impressed to read the work that has been done in Australia under the auspices now of the College of Emergency Medicine, and in particular the creation of the Emergency Nurse Specialist Standards. I've been through these standards and they're detailed, they're important, and I know that they underpin the work that you do. There is a particular provisions with regard to legal performance standards, the need for emergency nurses to understand relevant legislation and professional standards, to understand in particular the Mental Health Act, and to practice basically a duty of care. And there's also provisions in those standards for ethical behaviour, confidentiality of patients, the rights of individuals to consent, to withhold, withdraw or refuse treatment. These are very broad standards and I applaud their creation for the purposes of emergency nurses in Australia. But it is, I think, a pity that they don't go far enough, because I think they need to emphasise again and again that the fundamental principles of human rights law are the respect for each patient, for human dignity, for their autonomy, and for a prohibition on discrimination of any kind, but most particularly in areas of discrimination that come up so often: sexual orientation, race, poverty, lack of education, and one area that I've already mentioned, of course, migrants. Although much of my work has concerned those in long-term, indefinite immigration detention, the reality for Australians is that we now have over 30,000 people in our communities no longer in detention, who at best will get temporary protection visas, and at worst have 25,000 people have yet to be assessed as refugees. One of the greatest, strongest ways of diminishing a person's dignity when they're at a very low ebb is to say, we're not even going to assess your claim to refugee status. And that's the position for about 25,000 Australians at the moment. And the problems are starting to emerge in schools where families are unstable, they don't know their futures. Even if you're lucky enough to have a temporary protection visa, it's got to be reassessed every 3 years. The circumstances in which you came from will be assessed according to the Department of Foreign Affairs every 3 years. Children are presenting with anxiety in local medical facilities and so on. So we have a very, very long way to go, and I suspect emergency nurses are going to be among the groups most likely to see these problems. Well, one of the things that I've been asked to speak to you about is advocacy, and I'm really pleased to know that emergency nurses do see, as part of their professional standards, the obligation to speak up, and I think that underlies this conference and the kind of work that you do. Well, of course, it's extremely difficult, and I've mentioned this problem of human rights in a post-truth era, that we've always had misinformation, misstatements, propaganda, spin. But I think this is a new phenomenon in which we can see that a point made by senior political leaders and others in the community is not supported by the evidence. But we seem, in some cases, to accept that that's fine. We simply say, well, it's an alternative fact, as I think Ms. Conway said in relation to the inauguration of President Trump. It's simply another fact to take into account. And we've seen it in the newspaper in just the last day or so in relation to climate change and science. How is it that we've all been brought up in rational, evidence-based education systems only to find that we're tolerating inaccuracies, spin, and propaganda as though in some way there was a political right to an alternative view? In my view, there is no such thing as an alternative fact, and you know these facts far better than most. But one that I think concerned me particularly was the statement by the Minister for Immigration recently, that those very fortunate 40 or so who've been moved now from Manus Island to the United States are described by him as economic migrants. Now, they by definition could not be, because the United States, with its most rigorous processes, has declared them to be refugees and therefore entitled ultimately to permanent and safe settlement. But it's that kind of statement that I think is now so worrying, because its leadership matters so much, and we must be able to rely on the truthfulness of the leaders that we deal with. But that brings me back to you as emergency nurses. I'm not personally aware of this, but I do understand from your own material that not only do you speak up for your patients, and you speak from evidence and from truth and from being connected directly with your patients and the conditions of your patients, you are nonetheless subject to criticism in the media and can be subject to considerable opprobrium on occasion. Now, what do I say to that? Well, I've been subject to a little bit myself. I'm aware of how damaging it can be. But I think one of the things that's been most important to me as a lawyer is that once we've got the evidence and the facts right, and I'm confident of the law, and these principles I've been describing to you, there's nothing new or revolutionary about them. They've been around for a very long time, many of them from the time of the Magna Carta. Once you've got your evidence right, facts right, and in my case, the law right, why should you bend? Why should you waver? We must stand up for what we know to be the truth. If we make a mistake, well, you apologise and you back off. But if you've got your facts right and you're confident about what you're doing, and you have a professional responsibility that's a very heavy one, then I think it's important that you stand up for the truth and you stand up for the advocacy that you care about so much as members of the emergency nurses profession. So I encourage you to continue to be advocates, to be measured, to be evidence-based, not to be confrontational. I'm sure you wouldn't be, but nonetheless to stand without flinching, to stand up for what we know to be a serious issue in Australia, the high demands for emergency nurses' skills, the decline in resources, and the very high likelihood that those skills will be in even greater need as our population ages and as resources and other aspects of medical services are declined. So in conclusion then, I wanted really just to remind you of these fundamental human rights, essentially respect, autonomy for every individual, non-discriminatory access to treatment, and I know that that's what you do, so I'm really reminding you of what I know you already do. So thank you for having me. Congratulations for this terrific conference, and I look forward to talking to some of you later. Thank you very much. Thank you very much.
Perfectly executed and on time. I didn't have to remind anything. We have a small gift to pass on for those weighty and very impactful words. But are there any questions from the audience? Remember, the mics are here.
Thank you. You truly are an inspiration to us, and I know what you've been doing for human rights in our country and on a wider scale. It's just so impressive, but it just resonates so closely with what we do every day in our practice, and trying to stand up for our patients, and yet it can be quite a nasty, conflicting situation. So my question is, how do you keep going? How do you get through being shot down by some silly Prime Minister who's putting you down in a public way and trying to humiliate you? And that's what happens to us often in the clinical environment. So what gets you through that?
Well, I think we need a workshop to discuss this, because I'm sure you do this as well. I mean, obviously you can imagine that I've been a practicing lawyer for nearly 50 years, 49 years, and nobody's taken very much notice of me until I took this job and took on and called the inquiry as president of the Human Rights Commission. So you can imagine what it was like to have in the media both the attorney and the Prime Minister essentially saying that they had no confidence in me and essentially that I should resign. Now, that was shocking, really. But at the same time, and this is a reflection of the strength of our democracy, that the Australian Human Rights Commission is protected by its legislation, and the President is protected by the legislation. The whole point of having a President of a Human Rights Commission is to have somebody who's independent, that my job is to speak truth to power, if I can use that phrase, but to call to account a failure or to comply with human rights standards. So had I buckled under that and accepted another position that I was offered, I would have let down not only the staff of the Australian Human Rights Commission, but I think I would have let down everybody in Australia, because it's a unique position, it's a very unusual one. And had I not dealt with it, and had I bent and buckled under it, then I really would have let everybody down for the future. How would we ever have had an independent point of view? I may be wrong, that's fine. Take me on for the content of our reports. Tell me that the facts were wrong or the law was wrong, but don't attack me personally. And that's what they tried to do. At no stage did anybody ever challenge the facts in those reports. And those reports had gone time and time again to Parliament, and they were probably not even read, let alone acted upon. And that's an absolute national disgrace, and I will continue to speak up about that. Resilience, I don't know. Fantastic husband, a gin and tonic. Helps it.
Professor Shimon.
Gillian, thanks for a very inspiring talk. Your words and your remarks resonate with us greatly. If you could give our peers one piece of advice that went beyond the clinical context. In other words, if we could speak to our MP, what would you think we should say to them about changing the way in which we could change the human rights context in Australia? Would it be the Bill of Rights?
Would it be?
Would it be the Bill of Rights, to ask for a Bill of Rights?
Well, I think you should use the credibility that you have as specialist trained nurses. It's fine for me to say we should have a Bill of Rights, because lawyers do that sort of thing, especially with my background. And at the political level, there's so much need for a Bill of Rights. But I don't think it would be such a credible position for you to take. I think it would be more credible for you to say, this is what we're seeing on the ground. We're seeing people being moved from aged care facilities into our emergency departments, and we cannot cope with the lack of resources. I think if you can produce the factual evidence of what you are seeing and argue for better respect for the individuals affected by this, but use your professional credibility, which is significant across Australia, far higher than it is for lawyers, I have to confess, but use it. It's enormously powerful. And through your representatives, Wayne, I'm getting you into trouble here, but use your representatives to speak clearly with the facts, with the evidence, to say we need more resources to be able to deal with these problems and to train in this very highly specialised skill. That is where your credibility lies, and that's what I'd like to see.
Thank you.
Thank you. Good.